persons having anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Yes, Your Honor. The Commonwealth calls Sergeant Yuri Bukhenik to the stand.
Okay. And I do have that envelope, Mr. Lally. I have it.
Now, after you spoke with those three individuals, yourself and Trooper Proctor at the McCabe residence, where is it that you and Trooper Proctor went next?
We proceeded to the Good Samaritan Hospital in Brockton.
And where within the Good Samaritan Hospital did you go?
We went to the emergency department.
And within the emergency department, were you led to a specific room?
Yes, we were.
And what, if anything, did you observe when you were in that room?
Once in the room, we observed Mr. O'Keefe's body on the medical bed or gurney, and his clothing, which had been cut off of him, were on the floor at the foot of the bed, a couple of feet away at the foot of the bed.
Now, first, with regard to the clothing, what, if anything, did you do with regard to that?
After viewing Mr. O'Keefe's body, we proceeded to identify the clothing items and bag them into evidence bags, notating which item and a brief description about each item of clothing.
So let me ask you just a little bit about that as far as that process is concerned. So when an item of evidence is collected by you or by your units during the course of an investigation, is there sort of a policy or a protocol, or how are things, what do you do with things when you collect them and take them into custody and evidence?
If we deem an item to be of evidentiary value, we identify the item, we take a brief description of it, and we label the evidence bag with that description. We notate who's taking the item into custody, typically who located the item, the time that it's located, and the location from which it was seized or taken or collected.
And with regard to items of clothing, is that something that would be placed in just one big bag of clothes, or like how would those be packaged in an evidence bag?
Mr. O'Keefe's clothing, which was already in one big pile on the floor, we packaged all.
Okay. Jurors, feel free to stand up and stretch.
There is an ongoing objection to the use of the pronoun we. We did this. We did that. That's exceptionally, I think the court can tell after several weeks of trial, is exceptionally important that we know who did what. It's inappropriate for him to say we did anything. He needs to define who did what. I don't want to continually object, so perhaps Mr. Lally can instruct him to tell me what you did and what Trooper Proctor did. Otherwise, I'm going to object.
Well, you can do it on cross.
Except all the information is coming in muddled and vague. We put it in a bag. We didn't put it in a bag. Somebody put it in a bag.
All I got was we gathered. I mean, we are all here talking. You can then bring up what you say and what I say.
Right, but we are not holding that pen. You are holding the pen. I mean, that is my problem with that kind of testimony. It gets very garbled and muddled, and I have to correct it. I have to protect the record. I don't want to have to object to every single question if he uses the pronoun we. He needs to testify to what he did or what he observed somebody else do. That's all.
What do you say?
I don't think the term we is objectionable. So, I mean, counsel can object all he wants, but I mean, as far as, again, I think the court is correct in that these are questions counsel can explore on cross as far as his recollection as to what he specifically did versus what someone else specifically did.
Then I have to go over every single question that he asks on direct. It's extremely inefficient. It is an easy instruction to give the witness. Please testify to what you did and what you saw. I'm asking. It's super simple. That's all.
All right, I'm not sustaining your objection. Mr. Lally, if you choose to say who did what, fine. If you don't, then you can do what you want with it. And I understand where all of this is going. Let's just get through the sort of non-prejudicial stuff.
Okay.
And so, I'm sorry, Sergeant Buchanan. When you come into the hospital room where Mr. O'Keefe's body was, there's clothing items that are on the floor, is that correct?
That's correct.
And do you recall how those clothing items were in relation to each other, in relation to the floor?
They were positioned on the floor in a pile stacked on top of each other, and they were in the condition of being soaking wet.
And with regard to those items that you observed on the floor, what, if anything, did you and or Trooper Proctor do with reference to those clothing items? Objection.
I'll allow that.
Once we went through the clothing, we collected each item and put it into a large evidence bag. We double bagged it due to the wetness of the clothing, so it would not seep through. We also identified the fact that there was only one sneaker. So I requested that Trooper Proctor contact the paramedics that transported Mr. O'Keefe from 34 Fairview to the hospital and have them once again check their ambulance to see if there was another sneaker inadvertently left behind in the ambulance vehicle.
So as a result of your assignment to this unit and that sort of exclusivity of jurisdiction over unattended deaths within Norfolk County, if you know approximately how many death investigations have you been a part of over the course of your work with the State Police Protective Unit?
Over the last 9 years, I would venture to say it's over 500 death investigations that I was a part of.
And Sergeant, over the course of your involvement within those investigations, if you know, how many of those investigations involved some indication or some type of head trauma?
Scores of investigations that involved some sort of head trauma.
And through the course of your investigations, in those cases that have involved scores of head trauma, have you been privy to information as far as medical findings, autopsy reports, things of that nature in relation to those prior investigations?
Yes, sir, I have been.
Now, with regard to your observations of Mr. O'Keefe, with regard to his eyelids, what if any observations did you make, and what if any? Well, let me start just with the physical observations. What if any physical observations did you make of Mr. O'Keefe's face and body in general?
His face, I observed the swelling and the discoloration being produced through the blood pooling in the eyelids.
Yep, so just your observation, so the swelling and discoloration.
Move to strike.
I'll strike the remainder of what you've said.
I also observed a cut to his nostril and an eyelid, which was very small in size, which would have been produced by a...
Objection.
Yeah, so we'll leave it at that. Next question, Mr. Lally?
Based on your training and experience, what if any conclusions or what if any opinions that you have in regard to the swelling around the eyes?
Objection.
Yeah, I'll see you at sidebar here.
So he can't give medical testimony. He can say what he's observed here, and he has observed in other instances, but he can't say what this was caused by based on his experience.
Okay.
That is the nature of the objection?
It is
Okay.
understood.
Yes.
So, Sergeant Buchanik, with reference to your prior death investigations, have you had occasion to make observations of bodies that there was a later determination of some sort of subdural hemorrhage?
Yeah.
I'll allow that. Have you made those observations? Have you been part of those investigations?
Yes, Your Honor. Yes.
And what you observed in regard to Mr. O'Keefe, was that consistent or inconsistent with what you had observed on those prior investigations?
Objection.
That I'll allow.
It was consistent.
Now, in addition to the injuries that you observed to Mr. O'Keefe's face, what, if any, injuries did you observe to his extremities?
His extremities produced abrasions to his upper forearm and lower bicep area on his right arm.
And just as you use that term, I'm not asking for any sort of medical definition, but as far as you use that term abrasions, what do you understand that term to be?
I understand that term to be a injury sustained through blunt force trauma or friction to the epidermis of the skin where a crushing of the vascular system occurs and produces that type of sign on the skin.
And from your observation of the injuries to Mr. O'Keefe's arm, which arm was this again?
It was his right arm.
And as far as your observation of those injuries to his right arm, what, if any, as far as the consistency of those injuries, what, if anything, did you note or observe in reference to those?
Objection.
Consistency with what? With the,
Let me rephrase it.
Yeah.
How were the abrasions that you're describing positioned in relation to each other?
Each abrasion appeared to me to be linear and concentrated in a specific location on the arm. It didn't go any further north of a point and did not go any further south of a point. So it was concentrated in the elbow, a few inches below the elbow, a few inches above the elbow on the right arm.
Your Honor, may I approach?
yes.
Another item, sir, you recognize that?
Yes, it's the right sneaker recovered from the hospital room.
Your Honor, with the court's permission, if the witness could remove that item from
Yes.
the bag. Wait for the jury. Make an approach, please.
Okay.
My issue, now that we've started to go through this, is this officer did not bag these items. His name is not on the items. His handwriting is not on the items. And some of the items, for instance, the orange t-shirt. Why I'm confused, why it's confusing, that's not the bag that orange shirt came in. That's been completely changed. That orange shirt and the gray shirt were bagged together, and that's the only evidence I've got. I've got a bag that says orange shirt and gray t-shirt. Reverse that. Orange t-shirt and gray sweatshirt bagged together by Proctor. And now we've got other bags, and I don't know who, I can't see that far. I don't know who bagged these, if there was.
What do you say?
Your Honor, as far as when the items were initially bagged, this witness was present for when that occurred. This witness was also present when counsel was present at our office, when counsel came in to view these items, and they were all.
No, he was not there.
He was.
Go ahead.
Yes, he was.
Finish your.
And these items were bagged as they are now at that time as well. So I don't know what the surprise is.
Well, I didn't see anything. Bag to back up. I was at the office to look at the clothing. They were cut open and placed back in the same bags that they were cut open from. They weren't changed. The bags weren't changed. This is the first time I've ever seen Bukhenik in person in my life. And if he was in the office, he may have been in the office. He was not in that room.
He was in that room.
Tully was in the room.
Tully was in the room. Chris Moore was in the room. Sergeant Bukhenik was in the room. Sergeant Bukhenik left at some point when the items were taken out because he accompanied Ms. Gaffney and Trooper Guarino for the... But he was both present at the Foxborough Barracks when we were there with the vehicle. And he was present in the conference room, in the office, when all of those items were taken out of the bags. And he wrote a report in regard to that.
Okay, my issue is, I'm not discounting that. There were a lot of people in the room, and I don't discount Mr. Lally's memory. Mine may be faulty. I don't know where the original bag is that Mr. Lally showed yesterday with a different witness. It's not that bag. That is my issue, is how did this get rebagged? I mean, the bags are important in this case, but some cases they're not. In this case, they are.
All right, you're not disputing this is the orange t-shirt?
No.
All right, so let's put this in and then we can figure out after how you go about it.
This is a chain of custody issue.
Yes, this won't go into evidence at this point. It may well be that you have to do it through cross.
Right, okay. I just wanted to note it. Thank you.
Okay.
Continue, Sergeant.
You are unmuted.
All right, Mr. Lally.
Yes, thank you, sir. If you could return that to the back, please. Introducing minutes of next.
Yes, I'm going to. Thank you.
May I approach one at a time? My apologies.
No, I guess I should have said no objection with what we discussed.
I understand.
Thank you.
Your Honor, may I approach the witness again?
Yes.
If there's anything with last item from that set, do you recognize that?
Yes, it's a bag containing a blue jeans, black belt, and plaid boxer shorts.
And, Your Honor, with the court's permission, may the witness remove just the jeans and the belt from the back?
Yes.
Thank you, sir. You can return that to the back, sir. Your Honor, the Commonwealth will seek to introduce and admit as the next exhibit.
Okay.
No objection, Your Honor.
Thank you. So are you not displaying the third item, but it's going into evidence? Or is it just the jeans and the belt going into evidence?
The jeans and the belt into evidence, Your Honor, with the court's permission.
So we can mark the bag and we'll remove the third item during a break. Thank you. All right, so Sergeant, you'll be with us this afternoon. Why don't we take our lunch and recess? It's only going to be about a half an hour.
Thank you, Your Honor.
All right, so folks, we'll see you back here, let's say no later than 1:40, okay?
All right, Jerry.
You are muted.
Thank you. Maybe see the photographing session.
All right, Mr. Lally.
May we approach this briefly?
Okay.
Your Honor, this is a question in reference to those photos.
Are you putting them in right now?
I can wait if the court wants me to, but
I'm having trouble.
Yes. Did you hear that?
No.
Would you repeat yourself?
yes, Your Honor, I don't have to put them in right now, but that was my intention, is to just clean up and leave from the hospital, basically.
All right. So I just need like a minute to. I am going to give a gruesome photograph instruction. I just need a minute for that.
Oh, sure.
You can start laying the foundation, I guess.
Okay.
The other thing is on the statement, the recording from the Milton Barracks. You sent around a link as to what we had talked about before.
Yes, Your Honor.
So in order for me to give an instruction on that, I need to know. I thought we were keeping out the fact that she was in custody. It was just that she was at the Milton Barracks.
Correct.
So if she's not in custody, they don't have to give her Miranda warnings.
Right.
So I don't then intend to draw attention to the fact that she is there by saying she needs to be given Miranda warnings.
I totally agree.
The statement itself, obviously, still needs to be voluntary.
Right.
I just won't mention the part about Miranda warnings if you tell me that you don't want me to.
That's a good catch, and I do not want you to.
Okay, so you can lay the foundation on that. It will take me a minute or two to find the instruction. Okay, thank you.
Mr. Lally, do you want me to give my instruction now or in a few minutes?
Just about 30 seconds.
Okay.
So Sergeant Bukhenik just placed 3 photographs before you. Do you recognize what's depicted in those 3 photographs?
I do.
And what do you recognize those to be?
That is Mr. John O'Keefe.
And what's contained within those photographs is that a fair and accurate portrayal of what you saw of Mr. O'Keefe's body at the Good Samaritan Hospital on January 29th.
Yes, it is.
You want to make approach again?
Yes.
You're on the Commonwealth to seek to introduce and admit.
All right. So there's no objection, right? All right. So, folks, the Commonwealth is introducing into evidence through this witness certain photographs that are not pleasant and may be considered graphic photos. Sometimes evidence is presented that creates an emotional reaction in jurors. For example, it's natural and understandable to feel sympathy and empathy when you hear about a person who was injured in some serious way or suffered in some way or who has passed away. But as jurors, you've taken an oath to follow the law, and I instruct you that you must separate any emotional reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony, and you must find the facts in this case based only on the evidence. You can't find facts or base your decision on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, your verdict must be based solely on the evidence and my instructions on the law. All right, with that, Mr. Lally, those photos will be in evidence.
Thank you. Your Honor, with the court's permission, may publish just briefly each of the 3 respective photographs.
Yes. Thank you.
Now, as far as during any time that you were on scene or at this residence in Dighton, did you yourself or did you observe Trooper Proctor touch that vehicle at any point in any way while you were there?
No.
And did you observe Officer Barrows or any other personnel beyond the tow truck driver touch the vehicle in any way?
No.
And as far as the tow truck driver was concerned, did you observe that individual touch anywhere in the rear passenger side area of that vehicle at any time that you were there?
No.
So then you proceed inside the home, and when you get inside the home, where did you go and who, if anyone, did you speak with?
We were directed by Mr. Reed to the living room where the defendant was seated on the couch. She had her laptop on her lap and her phone resting on the right armrest of the couch.
Now, in addition to the defendant and her father, who, if anyone else, was present when you talked to Ms. Reed?
The defendant's mother, Mrs. Reed, was also present in the home.
And the defendant's mother and the defendant's father, were they present throughout the course of your interview or your discussion with Ms. Reed?
Yes, they were.
And at any point in time, did you ask them to leave or anything like that?
I did not know.
Now, with respect to, can you describe sort of the demeanor or the tone of the conversation that you had with Ms. Reed that afternoon?
It was polite, courteous. She had just went through a traumatic event, so we were considerate of her losing her boyfriend. And we had a normal tone conversation. We were in the information gathering, fact-finding portion of the investigation. We simply wanted to collect her recollection of events that she remembered.
And so throughout the course of this interview, how were you are you standing? Are you seated? Or how are you positioned in relation to Ms. Reed, and how is she positioned in relation to you?
She was sitting on the couch. We were standing across the room. I don't recall if there was a coffee table, but if there was a coffee table, we would be standing on the opposite side of that coffee table, if there was one present. I do not remember if there was one present. But that's the distance, approximately, from me to the defense table.
And if you could describe to the jury sort of how did that interview or how did that conversation begin? What was said?
First things first, we introduce ourselves, advise the individual we're speaking with who we are, where we work, and what we're looking to find out. The defendant was advised that we're looking to get a recollection of the events, what happened, what she observed, what she remembers from the night before, and to walk us through the last 24 hours or so of activity.
And prior to...
Do I need to give an instruction, Mr. Lally? I'm not sure exactly. Why don't I see counsel at sidebar for a minute?
So they determine ultimately that they are not going to really interview her now?
No, they do. They interview her.
All right, so at this point, she is clearly not in custody. We're not asking for Miranda. It's strictly voluntary statements.
Correct.
Why don't I tell you what I intend to give, and then, if there is any...
Sure.
You're about to hear testimony about statements allegedly made by the defendant, allegedly concerning the crimes charged in this case. Before you may even consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntary, freely, and rationally. In determining whether any statement made by a defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police, or questioning by the police, and the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor. You must consider the totality of the surrounding circumstances.
The only thing I would ask the court to add is when you use the example of age, mental capacity, etc., is to include a statement about potential for any medication that she might have taken. There is evidence that she was heavily sedated in the hours before this.
So that's why I'm talking about mental condition. I'm not going to specifically mention medication.
Okay, that's fine.
Other than that, you want me to stay away from Miranda, as we discussed?
Correct.
And you're satisfied about just voluntary and the circumstances?
With the noted request that I made, yes, I'm satisfied.
We haven't heard anything about that yet.
Okay.
Thank you.
Muted.
All right, so I interrupted you, Sergeant, and I'm going to instruct you jurors, okay? We're about to hear testimony about statements allegedly made by the defendant, Karen Reed, allegedly concerning the crimes that are charged in this case. Before you may even consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether any statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or questioning by the police, and the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor. You must consider the totality of the surrounding circumstances. I'll instruct you about this again at the end of the case, but for purposes of, as you hear the testimony, that's the lens that you have to sort of hear it through. All right, with that, Mr. Lally?
Thank you, Your Honor. Now, Sergeant Bukhenik, when you began to speak to the defendant, prior to any sort of substantive conversation, what, if any, conversation did you have with her about the conversation you were going to have?
I just asked her to recount any events and the history between the actions that were taking place.
And how did she initially respond to that?
She stated that she's willing to answer our questions. She just doesn't want to go into too much detail about what what transpired. And given the circumstances that she had just lived through, I understood and gave her that courtesy.
And as far as that interview or that conversation went, can you describe that conversation or the contents of that conversation to the jury?
Absolutely. The conversation was normal tone of voice like I am speaking to you right now. Ms. Reed responded in the same tone of voice, answered questions. The content of the conversation began with her saying that, as I stated, she doesn't want to go into too much detail, but she was willing to answer our questions. We asked what she had for plans, what she had for as far as activity the night before, leading up to Mr. O'Keefe being discovered. She stated that she was in a relationship with Mr. O'Keefe that morning, meaning the 28th of January. She got into a fight with Mr. O'Keefe over what the niece and nephew were being fed for breakfast, or what they had for breakfast. She went on to say that she met Mr. O'Keefe at C.F. McCarthy's approximately 9 p.m. the night of the 28th of January, 2022. She stated that the gentlemen were drinking, consuming beers, Bud Lights, and she was drinking vodka soda. Prior to moving on to the bar at Waterfall, the defendant was asked where she parked her vehicle. She told me that she parked her vehicle on Washington Street across the street from C.F. McCarthy's, facing northbound. So the vehicle was on the side of Waterfall Bar and Grill. We went on through the conversation, the interview, to the Waterfall restaurant, at which point she was asked if she left C.F. McCarthy's with a beverage or a container from that establishment, to which point she stated that she did not. She also confirmed that Mr. O'Keefe did not have any injuries on him when she interacted with him at C.F. McCarthy's or the Waterfall. He did not get into any verbal or physical altercations with anyone to have sustained those injuries. She stated that once at the Waterfall, they stayed for approximately an hour, hanging out with acquaintances. And then they left the Waterfall. She drove them to, after they were invited to a residence, she drove them to a location in Canton where she dropped Mr. O'Keefe off. She was asked if she saw Mr. O'Keefe walk into the home at 34 Fairview, and she stated she did not. She stated that she made a three-point turn after dropping him off and left. She was asked whether or not Mr. O'Keefe, excuse me, let me back up. She was asked if she knew, how she found out about the damage to her vehicle, to which she stated, quote, "I don't know, it happened last night," end quote.
Gentlemen, if you could just pause there for a moment. Sergeant, direct your attention up to the video on the screen just for orientation purposes again. First of all, do you recognize what's depicted in this video?
Yes, I do.
So what do you recognize it to be?
That is the Sallyport two-bay garage at Canton Police Department with the antique Canton Cruiser on the bottom of the screen, and the open spot for a vehicle in the middle of the screen with the four-wheel drive all-terrain vehicle at the top.
Now, as far as, again, for orientation purposes, the driveway that the jury just witnessed in the prior exhibit, is that to the left of the screen, the right of the screen, or something else?
The driveway is to the right of the screen.
And this vehicle, the defendant's vehicle, is taken into the garage on the opposite side or to the left of the screen, is that correct?
Correct.
And this gentleman, if you could, please.
Your Honor, may we approach briefly?
Okay, could you pause that, Ms. Gilman?
Your Honor, I don't know the name of this file, but all of us just put our heads together to try and figure what this video is. We do not have this. I hesitate to say we don't have this video. We have not seen this view of this video. We do have Sally Port video. It's the one from the opposite side.
This was separately provided at a later date.
When was this provided?
It was provided specifically after Mr. Yannetti, during a pretrial hearing, had mentioned that there was no video and it was grainy. I don't have the exact notice of discovery in front of me, but this was absolutely provided well prior to trial.
How long is it?
So it's motion activated, so it skips over. I mean, I think it stands probably about 20 minutes, but I think the entirety of the video is probably about 8 or 9 minutes.
It is 8 or 9 minutes.
I believe it's much shorter than that. I think it's about 5.5 minutes or so.
All right. Typically, the jury has asked for like a 3:15 afternoon break on days we go to 4:30. I can give them a break now so you can see it if you want.
Yeah, I desperately need to see it, or we can move past it and give them a break at 3:15 if there is another area that we can cover and make it more.
I just feel bad where it's already up there, and
I do too.
we'll take a 5-minute. We will take a 10-minute break now.
Okay, thank you for that.
A short afternoon break on our long days at about a half an hour, but I think the better use of our time is to give you a 10-minute break now. And then we'll go straight through till 4 o'clock. But if anybody needs a break, we'll know.
All rise for the court, please. Follow me, please.
Jim.
So, I need you for just a minute.
Sure.
So, I just asked Mr. McDermott to print out the docket. Oh, that's for you. Take it, please. We will print out the docket to find out whatever the hearing date was and when your notice of discovery was.
It was right around April 23rd, discovery notice, I believe.
Is that April 2023 or
24?
April 23rd of 2024?
Yes.
So within the last 2 months, after the start of trial.
All right. Why don't we watch it?
Sure.
Don't if may the witness leave the stand just for a moment.
Sure. Yeah, we'll see you back here in about 10 minutes, Sergeant.
You are unmuted.
Okay, so you want us to watch this now?
If it please the court, yes.
Is that the end of it, Mr. Lally, or
I believe so, yes.
is that the end of it, Ms. Gilman? Okay. All right, lights on, please, Dave. Thank you. All right, so I have a copy of the printed docket on 424. Paper number 347 was the Commonwealth's Notice of Discovery XL. I just asked Mr. McDermott to print it for me. Our printer up here doesn't work. All right, so that was before we impaneled. That was the day, I believe, of the long motion in limine trial. All right, so we'll take a 5-minute break, okay?
Thank you, Your Honor.
All rise. Thank you. Be seated. Close back.
All right, so we're ready to pick right up where we left off?
We're ready. Thank you, Your Honor.
So I'll just be clear, the objection's overruled, Mr. Jackson.
Thank you.
Sergeant, we're going to start up again with the video.
Given.
Your Honor, for the record, I believe we're picking up where it was paused, which was 5:35:36.
Okay?
And Mr. Officer, we can have the lights back on. Thank you. Now, Sergeant Bukhenik, with regard to Mr. O'Keefe's house at One Meadows Avenue in Cary. At some point, did you become aware throughout the course of your investigation that there were exterior cameras affixed to that residence as well?
Yes, I did.
And those were Ring cameras, is that correct?
That's correct.
Now, with respect to the investigation, what, if any, steps were taken in order to secure any of that footage from the exterior of the house from the Ring?
Objection.
No, I'll allow it.
We applied for multiple search warrants.
Objection.
All right, I'll see you at sidebar on this.
What is the nature of the objection?
This witness, foundation. This witness did not write the search warrants. This warrant did not analyze the videos. This witness did not look at the videos. He has nothing to do with those videos. Trooper Proctor did all of that.
What do you say about that?
Sergeant Bukhenik has looked at all of the videos. He supervises Trooper Proctor. All I'm asking in reference to the search warrants is he's aware these search warrants were obtained. He's seen all the videos. He can testify as to how they're kept and how he viewed them just as easily as anybody else.
No, he can't. I've seen the videos as well, Your Honor. That doesn't give me the foundation to establish how they were recovered. He has to call Trooper Proctor. I know he doesn't want to, but he's going to have to.
And I know you want him to, but I'm just focusing on what's before me. So let's lay a foundation.
Sure.
Muted.
And so, sir, during the course, let me ask you this. As far as this or any other investigation is concerned, how is it that members of your unit sort of work through an investigation or work on a case?
We,
Objection, Your Honor.
No, I'm going to allow that.
as a case comes in, we address each case on individual basis based on the evidence that is presented through testimony and physical evidence that is recovered. That is what guides our investigations, and we then develop leads and process information collected. Sometimes information needs to be collected from third-party holders of data or service providers, at which point to access that data, we apply for search warrants, which are guided.
Okay, so leave it, move on from that.
Thank you.
So you apply for search warrants, we'll move on from that.
So, Sergeant, my question is more geared toward as far as individual personnel within within your unit. How is it is an investigation conducted as far as one trooper does everything, or is it a collaborative effort, or how is that? How is that?
The reason I say we is because every investigation takes the entire unit typically to put an effort in to conduct interviews, analysis, and so forth. So it's a team effort each and every time. No investigation is a one-man show. That's why we call it a case officer, not a lead investigator. Because the case officer organizes the individuals to assign different tasks and collect and organize the data that comes back from the third-party providers and from the interviews that are conducted.
As far as the interviews that are conducted through the course of this or any other investigation, is there ever an interview that's conducted just by one trooper or one person in any investigation that you've done with this unit?
It is, no. We conduct interviews with two people, whether it's a trooper and a local detective, or two troopers assigned to our office, other state police agent unit within the agency.
Now, as far as the case officer, who was a case officer on this particular investigation?
The case officer in this investigation was Trooper Michael Proctor.
And Trooper Proctor works under your supervision, is that correct?
That's correct.
So as far as a search warrant for the Ring video from One Meadows Avenue, who specifically sat down, put pen to paper, and wrote the search warrant?
Trooper Proctor was the affiant.
And as far as from that search warrant, are you aware of the materials that were provided by Ring in response to that search warrant?
Objection.
I'm going to allow it.
I am aware of it.
And have you reviewed both the material as well as the videos that were provided by Ring in response to that search warrant?
I did.
Now, with reference to those with reference to those videos, specifically, did you observe if you know, with respect to those videos, how were they sort of ordered sequentially, when in the manner in which they were provided, as far as date, time, things of that nature?
Objection.
Ask it differently. Ask it differently, Mr. Lally.
So the videos that you received from Ring that you've reviewed, correct?
Yes, I did.
Objection.
No, I'll allow that. So he's reviewed videos from Ring. Next question.
What, if any, information did they contain as far as date or time?
The data provided back from Ring provided videos. There was no date and time on the labeling of the identifier, unique identifier for each video, but it was presented in a sequential order, knowing that the last video presented from the provider was the last video within the scope of our request, and the first one being the first in that timeline.
In the scope of your request, the scope of the request of the warrant, what time frame are we talking about?
Objection.
I'll allow that.
The first warrant we requested from January 24th at midnight through January 30th at midnight.
And with respect to those videos that were provided, you reviewed each of those, is that correct?
That's correct.
And Your Honor, with the court's permission, I would ask to publish certain of those videos for the public this time.
So are these, why don't we come to sidebar?
So, are these already in evidence?
They are in Exhibit 6. Yes.
He has no foundation for these. They are in Exhibit 6 because Trooper Proctor is expected to testify. And when the foundation for them, if they're going to be played for the jury, he wasn't the affiant. He didn't ask for them. All he did was review them. Any one of the jurors could review them. I could pick someone from the audience to review them, but they can't come into court and establish the bona fides of the foundation.
So it's in evidence, and that's one thing. There is some case law in Massachusetts on acknowledging police officers working together. It's not very helpful to defendants. So, yes, you may play that.
Thank you.
Objection?
Yes.
You are unmuted.
Ms. Gilman, if I could have from what's been previously marked as Exhibit 6, first video 119. Now, from this portion of the video, Sergeant, what, if anything, do you observe the defendant and Mr. O'Keefe doing in reference to C.F. McCarthy?
Once the defendant got drink number 7, the defendant and Mr. O'Keefe walk out of C.F. McCarthy's, the defendant holding the beverage, tall cylindrical glass in her hand.
Thank you, sir. Your Honor, may I approach?
Yes.
Ms. Gilman, you can take that down. I'm sorry. So I'm showing you a 5-page document. Asking you to review that, look up when you finish. And do you recognize that document, sir?
Yes, I do.
And what do you recognize it to be?
I recognize it to be a series of transaction receipts from the tabs at C.F. McCarthy's.
And are these the transaction receipts or tabs that you received, you and Trooper Keefe received from C.F. McCarthy's on February 1st, 2022?
Yes, they are.
And with reference to those receipts or tabs, to whom, if anyone of significance, do those tabs pertain to?
The first one for 5280 was opened under the bar tab, Karen A. Reed.
And is there also a receipt from John O'Keefe?
Yes, it is. The transaction through the credit card, being a MasterCard for 5280, was paid by Mr. John J. O'Keefe.
And with reference to the items listed within that particular receipt, what, if any, items of significance do you observe listed on the receipts?
Under Karen A. Reed's receipt, 1 Tito's, $10, 1 Tito's, $10, 1 Coors Light, $5.
Objection, Your Honor.
Sustained.
May I approach on?
Yes.
Commonwealth will please introduce and admit as an next exhibit.
We probably should approach
Okay.
briefly.
What is your objection?
I just don't want to sound like a complete idiot in front of everybody. I thought these were already presented.
The waterfall.
The waterfall. I've been waiting for these ones.
I knew I was going to sound like an idiot. My main objection is there is no foundation for these. They could have been done in a handoff. He asked for them. He received them, but he doesn't know.
Which is why I thought we went through that whole video.
No, I thought, he can't say that she was drinking Tito's. I don't know that she was drinking Tito's. Maybe.
What do you say, Mr. Lally?
She, in her interview with this sergeant, indicated that she was drinking vodka and soda.
I'm not even arguing that. I'm trying to establish that if this is going to come in, it needs to come in through a custodian of record, not through the officer. He is not the custodian.
But the video came in. So in connection with the video, I'm going to let this in.
Okay.
Your objection is noted.
Okay.
You are unmuted.
And so Sergeant Bukhenik, on those receipts from C.F. McCarthy's under both Ms. Reed's receipt and Mr. O'Keefe's receipt, there was Tito's vodka listed on the receipt, correct?
Correct.
Now, also on February 1st, what, if any, other establishments did you go to in the town of Cambridge?
Myself and Trooper Keefe went up across the street to the Waterfall Bar and Grill and retrieved transaction receipts and video from there as well.
And as far as the video is concerned from that establishment, have you reviewed that video as well?
Yes, I did.
And with regard to the receipts from that establishment, you reviewed those as well. Is that correct?
That's correct.
Your Honor, may I approach?
Yes. Mr. Lally, why don't we end for the day? It's been a long day. Everybody ready to go home? Yeah, okay. All right, so Sergeant, we're going to meet you back tomorrow, and I'll ask you to just follow the jurors out when they leave. So jurors, the same reminders, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. We'll see you tomorrow morning.
All rise for the court, please. Jurors, follow me.
I will see counsel at sidebar about scheduling, please.
Sidebar, please.
All right.
My apologies.
That's okay. How much longer do you have with him?
I'd say about 45 minutes or so.
Okay. How long do you think we'll need to finish tomorrow? It's only until noon. I'm not rushing you. I'm just curious.
No, I understand. I guess that's a little bit of an unknown because I was going to bring this up, and now is as good a time as any. If the Commonwealth is not going to call Trooper Proctor, and a lot of this information is coming out through Trooper Bukhenik, I expect it to come out through Trooper Proctor. If that's not the case, that changes my entire cross-examination of Trooper Bukhenik.
Okay.
So I sort of need some clarity. I mean, I've asked the Commonwealth several times, and it shouldn't be, I don't want to get ambushed, and I don't want to have to adjust on the fly. I should have the opportunity, a reasonable opportunity, to deal with the lead case officer who is going to testify in this case in an appropriate way, because there is so much that rides on that. So all I'm asking is if Proctor is not going to testify in the Commonwealth's case, then that changes the way I cross-examine Trooper Bukhenik significantly. If Trooper Proctor is expected to testify, my cross of this officer is probably an hour, maybe less. If it's not, then there is a lot of ground to cover. I could be 4 hours.
Okay. So I don't care how long you take. You can take days. You know as well as I do, the ambush is if you're not told a witness is going to testify, right?
I understand.
It's what defense counsel does. You're preparing one way or the other. I'm not asking the Commonwealth whether they are calling him or not. I mean, he's on the witness list. This is a big deal, right?
It's a big deal. Yes.
So if it were me, I'd prepare for both and see how it goes.
Okay, fair enough.
I'm just saying, so I don't care how long you take. If you don't know, you don't know. That's fine. Redacted portion of the transcript regarding a juror conflict.
Of June?
Of June.
Oh, wow. Okay.
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 My expectation, just as far as, and obviously this could change, but my current expectation is I should be able to rest the case in chief on either the 17th or the 18th.
Okay. And the 19th is a federal holiday.
Oh, it is?
It's Juneteenth.
Juneteenth.
I had in my calendar that there was a potential off day on June 11th, which was Tuesday coming up.
Oh, is there? I was told that the Commonwealth
I believe there is.
needs something personal to you. You need a day off?
Yes, Your Honor.
Okay.
We are off Tuesday then?
Yes, we'll be off Tuesday. I have not told the jury that yet.
Right.
I'll tell them tomorrow.
Just while we are on scheduling, Your Honor, we have gotten the heads up regarding the order of witnesses. After Trooper Bukhenik, there are 2 minor quick witnesses and Trooper Paul. And then we don't know anybody after that.
Well, it sounds like you may not get past Trooper Bukhenik tomorrow.
Maybe not, but we have almost a full week next week, and we'd like a heads up as to who is coming after that.
Okay, so you'll provide that tomorrow, Mr. Lally?
Yes, Your Honor.
All right. So, the 11th. I will tell the jurors tomorrow that we won't be in session. Okay. And it was the 26th. More redactions in the transcript in relation to the juror conflict. So we'd go from 12 straight through to 4 with a short afternoon break.
Sure.
One last redaction regarding the juror conflict.
Right. Okay.
Given what Mr. Lally has just graciously told us about when he expects to wrap this case, that means our witnesses are going to be obviously propped up. I want to make sure that there is absolutely no delay. I'm not sure if this is a court question or if it's a Mr. McDermott question. I don't really know logistically how to set our witnesses in the building. In other words, if I have 5 witnesses, I don't know where they go. I don't have an anteroom for them. I'd like just a little clarification so I can start preparing.
Okay. It's something we'll talk about. I have to talk with security about it.
Okay, I just wanted to put it on the radar.
All right. So June 21st, that's a definite, right? Did you find out if it's more than a day or a full day? June 21st, I have a sentencing that involves, it's post-Mathis, a very serious case that was tried here twice in the last year. I expect that will be all day on the 21st. That's problematic.
I could be wrong on this, but I believe the court had already told the jury, or at least told us, that the 11th was off and the 21st was off.
I never said the 11th was off. I may have said the 21st was off.
At least the 21st? I have it written down.
Okay, I'll check. Did I tell you the 21st?
I didn't have that in my calendar.
I didn't either.
I had the 11th as a possible date.
I'll check, because I know I sent it to security, so I'll check with them.
Also, on the 13th, Thursday the 18th, we are going a full day.
The 8th. Every day is a full day from here on in, unless we are told otherwise.
Okay, good.
I think we said that to the jury last week.
Judge, I'm sorry, the 13th.
Yes. Next Thursday will be a full day.
That's actually very helpful because I think at that point we'll be with witnesses coming from out of state. So the more stretched out we can get.
Next week, we have 4 full days then,
Yes.
right?
Yes.
And the week after, 4 full days.
No, 3 full days because Juneteenth is a holiday. How long do you think your experts will take?
I think we are going to have in between 8 and 10 witnesses total. 1, 2, 3, 4 experts.
And we need voir dires. We need voir dires of the experts, right?
Yes, I anticipate we'll have another motion to exclude at least one of the experts tomorrow. And then yes, I think we need a voir dire of the remaining ones because I don't know what their testimony is going to be, with the exception, I think, of Mr. Green and Dr. Sheridan. Dr. Vanny, I have no idea. And the ARCA person, I really don't know.
There's going to be 2 from ARCA and Dr. Vanny both. The voir dire, it is what it is. I expect if I could, excluding an extensive voir dire, I could get our case in chief done and over with, I think in 4 to 5 days of full testimony. Probably 4 full days of testimony if there is no extensive voir dire. My goal is to get it done in a week.
You've provided a lot of discovery, right?
I provided everything that we have. I can't make up discovery. I mean, I got a report, and everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows. They've got what I've got.
I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions.
Certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they are going to testify to the contents of the report, and those are definitely questions I'm going to ask. So I've got clean hands.
Who are those individuals? Which names?
Dr. Wolf, Dr. Rentschler.
Okay, all right. We'll see you tomorrow morning.
Thank you, Your Honor.
All rise. Court stands adjourned. What is now open and seating?
Could I see counsel at sidebar about a couple of things, please?
Hi. A couple of things about the scheduling and exhibits. One thing I'm going to do this morning is I'm going to strike Exhibit 463, the receipts. Mr. Jackson is right that there has not been an appropriate foundation laid. The others came in through the Waterfall, through the bartender. We need somebody from there.
Yeah, if I could just on that, I had Jean Demoulas on the witness list who I intended to call. When I talked to counsel about that, whether or not I needed to call that person in order to get in the video and or the receipts, I was told that that was fine. And they stipulated to that. So that is why I'm a little...
Let me talk to co-counsel about that.
Okay.
Perhaps I do want to avoid another witness if we can.
All right.
My biggest issue was Bukhenik reading from the receipts as if they are his.
No. So I went back and listened again last night. So he read the first 2 Tito's and then he read Coors Light before you objected.
Right.
When you objected, I immediately sustained it. And then I thought you were objecting for that reason. It was in, and you came to sidebar. And you came to sidebar and said you thought it was already in evidence, and I know it wasn't in evidence. And then you raised the authenticity argument. So you can talk about that, but it brings me to an important point. This is the first case I've ever tried as a judge where I don't really have access to the exhibits. They seem to be back at the DA's table, and I understand it's for organizational purposes. There was a time yesterday after that I was thinking, I haven't even read this. What I remember seeing, this was a grand jury exhibit, right?
Yes.
I don't remember seeing all of the last page that I just saw this morning when I took this out of where it was, the other gentleman's receipt or something. The bottom line is I need access to the exhibits so that if I have a question on it, I can look at it when Madam Clerk is marking exhibits or when I've seen the video for the 5th time or something, and I don't have that yet, and it's troublesome to me. So I would like all of the paper exhibits for each day to be held with the clerk where they're supposed to be held during the day, and if you all need them, the clerk will hand them to you. If I need them, the clerk can just hand them back to me. At the end of the day, I have no problem. I think it was great that the Commonwealth seems to be organizing these, which seems like a big job for you. This is 463. So how many more do we have? Do we have another 100 or 200 more exhibits?
In total, I don't know if it's 100, but it's probably somewhere between 15 and 75.
Okay, I get it. There are a lot of exhibits, but I would have appreciated having this yesterday. I do take them from the witness, but oftentimes I take them from the witness, and we come over here. I don't really have a chance to look at them. Those were my 2 points from this morning. Can you figure this out right away?
In 10 seconds.
Okay, I'll wait. Tim, you can line them up.
Yes, Your Honor.
I don't want Mr. Lally to have to call another witness to lay the foundation, which I'm sure he can. We'll just stipulate to it. Again, my only issue was Sergeant Bukhenik, who has no personal knowledge of any of the data on it. He's just reading from it. He spent like 15 minutes reading the Tito's.
No, and when you objected to it, I sustained it. That was prior to it coming in.
Right, so I don't think that it needs to be stricken.
All right, so you are not objecting to its authenticity. You are withdrawing your objection to its authenticity that you raised yesterday?
Correct.
Okay, that can be done. That's great, though. And the other thing, I will tell the jury today that we are off on Tuesday. They want to know where we are. And now I ask the court officer to ask the jurors. I have my sentencing in Lopez on the 21st. I may end up continuing that, which I know causes all kinds of problems for the DA's office, and I regret that. We can't keep these jurors any longer. I'm afraid they are going to go right into the 4th of July.
That's my fear.
All right, so we will figure out scheduling. But I did ask the court officers to ask the jurors if they were told the 21st was a day off, ask if they'd be available, and we'll know that at the end of the day. So before we break at 12 and give the Commonwealth and the defense to tell me a ballpark of when they think the jury will get this case for deliberation.
Will do.
Your Honor, there are 4 exhibit books that contain all of the exhibits. Do you want them up here?
I don't think we have room for all of them.
Can they be maintained in that corner, or do you want...
Sure, wherever you are. But whatever comes in today stays with the clerk from today. And at the end of the day, I don't mean the bags of evidence. It's the papers and photographs if you don't display all of them.
Would it be helpful to provide copies to the court in advance when we know certain things are coming in?
If you only have 53 exhibits coming in from here on, that would make things maybe easier, and I would just keep them here.
Okay.
It's problematic when I want to find something to look at, which happens a lot.
I understand.
All right, are we all set?
We are. So let us know. Talk during the break about when you think the jury will get the case.
Will do.
All rise, please, jury entry. Sergeant, do you recognize what's up on the screen? It has now been marked as Exhibit 481.
I do.
And if you could describe to the jury what's depicted in this photograph.
A red piece of plastic.
And Ms. Gilman, if I could have the next one, 766.
Can you use the pointer to show us where that is, please?
Yes, Your Honor.
All right, thank you.
Thank you. Ms. Gilman, 7682. And Sergeant, do you recognize what's depicted on the screen and has now been marked as Exhibit 482?
I do.
You know, I'm going to see counsel at sidebar for just a minute, please.
So have we not seen these before?
You have seen them as far as the lab photographs. What I'm trying to do as quickly as I can is go through not every single piece, but some of the pieces as far as where they are located, where they are found.
Okay, but I think we just saw 3 views of one in the last one. Just put it up and say, what are we looking at, instead of, can I orientate you to what's been marked? Just get right to it. And new, different things. I understand if you have to put pieces together to justify or explain how the lab got it, but just try to move it along. You are losing them, for one thing. I couldn't even see where that glass was. If he's going to put it up, have him show what you want to show. And again, when you look down, we can't hear you.
I apologize.
You don't have to apologize. Hold it up here and read it if you have to, but just keep your voice up because I am going to have to turn the air conditioning off.
Okay, no, I don't want that.
Okay.
You are unmuted.
I'm sorry, Ms. Gilman, 7682. Sergeant, do you recognize what's up on the screen as Exhibit 482?
I do.
And what do you recognize that to be?
A red piece of plastic.
Is that the same piece of plastic that pulls our image from the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7684. Sergeant, do you recognize what's up on the screen and is now been marked as Exhibit 484?
I do.
And what do you recognize that to be?
A white clear piece of plastic and a red piece of plastic.
And lastly, from this, sir, Ms. Gilman, if I could have 7687. Sir, again, do you recognize what's up on the screen? It's now been marked as Exhibit 487.
I do.
Now, Sergeant, with reference to the photos before you, have you had a chance to review that set of 10 as well?
Not this one yet, not yet.
If you could, please. Now, sir, if I could turn your attention to June 9th of 2022. On that date, at some point, did you have occasion to meet with the defendant?
Yes, I did.
And at some point during that meeting, did you have conversation with the defendant?
Yes, I did.
And was that conversation, or at least portions of it, memorialized in any way?
Yes, it was.
Your Honor, may I approach?
Yes.
I'm showing you a disc. Does that contain an audio recording, to the best of your knowledge? Does that contain an audio recording of a portion of your conversation with Ms. Reed on June 9th, 2022?
Yes, it does.
Your Honor, may I approach?
Yes.
I'll hold the seat to introduce the minutes of the next exhibit.
All right. No objection, Mr. Jackson? All right, folks, before we play this, again, please be mindful of the instruction from yesterday. So you're about to hear statements allegedly made by the defendant, allegedly concerning the crimes with which she's charged in this case. Before you can consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether the statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or any questioning by the police, the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor, and you must consider the totality of the surrounding circumstances.
Your Honor, with the court's permission, may we publish that to the jury at this time?
Yes, do you want to turn off the air conditioning? Is this very short, right?
It is very short, and if we could, please, yes.
Yeah.
Okay, you're aware he was beaten up by Brian Buccal and Albert. I mean, we're all in on the same joke, right? My tailing is correct and John was pulverized.
Okay. Now, Sergeant, on hearing that statement from the defendant, what was your reaction? Objection.
Sustained.
On hearing that statement, what, if anything, did you do?
I advised the defendant not to further speak.
Objection.
I'll allow that.
Now, at some point over the course of your investigation, were you made aware of forensic findings relating to the defendant's tail?
Yes, I was.
And specifically DNA findings?
Yes.
And specifically that there were...
Objection.
Sustained. Yes. You can turn the air conditioner.
So, Your Honor, what I intend to ask him and what I expect his response to be, what I'm trying to get into is the fact that a buccal swab was taken of him and Trooper Proctor and then sent off to the lab, not anything about the results. And I'm not going to be asking him about any positive results as it relates to Mr. O'Keefe, but just simply that he's aware that there were multiple contributors listed in the results. Therefore, he voluntarily provided his buccal swab to be submitted to the lab for testing.
All of that is predicated on hearsay. He can certainly testify. I don't think there's any issue of him testifying. Did you submit yourself to a buccal swab and give one? Everything else.
That's it. You can't say why he did it based on results. You can just say that he voluntarily did it, and if he saw anybody else do it if you want to.
Okay, understood.
Thank you.
You are unmuted.
You're back? Have one moment.
Yes.
So, Sergeant Bukhenik, on January 16th, 2024, at some point in that day, did you meet with a Sergeant Gallerani of the Needham Police Department?
I did.
And who, if anyone else, well, let me ask you this. As far as any other troopers from your office, who, if anyone else, was there with yourself and Sergeant Gallerani?
Trooper Mike Proctor.
And what was the purpose of your meeting with Sergeant Gallerani and Trooper Proctor on that morning?
Collection of our DNA.
And was that something that you did voluntarily?
Yes.
And how was it that the sergeant collected your DNA?
Through a buccal swab?
And were you present when Trooper Proctor submitted to a buccal swab as well?
Yes, I was.
And then as far as the swabbings that were taken from both yourself and Trooper Proctor, were those logged into evidence by you, or did Sergeant Gallerani take them with him when he left?
Sergeant Gallerani took him with it when he left.
Thank you very much, Sergeant. Your Honor, I have no further questions.
Okay. Cross-examination?
Thank you, Your Honor. Now I'd like to shift gears to a ring video that you saw yesterday. It's in Exhibit 6, video number 153. That may mean nothing to you. It's the 5:07 a.m. video of Ms. Reed's car pulling out of the One Meadows garage. Do you remember that video?
I do.
Okay. You indicated yesterday on questioning, under questioning by Mr. Lally, that Ms. Reed's car came in contact with or close to coming in contact with the other vehicle, the Traverse, in the video. Is that right?
The video, as I watched the video, I observed the vehicle come near Mr. O'Keefe's car.
Okay, that's what I want to talk about. With the court's permission, may we play that video one more time?
Okay.
If you can pull that up, and then I'm going to ask you to pause it and get out of the way. Okay? Okay, you just play that for a quick second, and then let's get pause it. Pause. Does that appear to be, I'm just pausing it in the first 2 or 3 seconds, does that appear to be the video that you saw yesterday?
It appears that way, yes.
Okay. Mr. Bates, if you could enlarge the area around the the left rear tire of the Traverse. I'm going to ask you, sir, if you'll pay close attention to what's been zoomed, and when the SUV gets close to it, I'm going to pause it and ask you another question. Can you go ahead and play this?
Your Honor, I'm going to object to this.
So why don't we pause the screen, take it down, and I'll see you at sidebar.
What is the objection?
As far as the enlargement and blowing it up on the screen, he can ask the witness to pay attention to observe the area of the screen, ask if he sees something. But as far as manipulating the video in this way, I don't think it's appropriate.
Your Honor, how many times has the Commonwealth asked Ms. Gilman to enlarge or zoom in on a photo or a video? They do it every...
I am going to let him do it. It's unfortunate that the DA's office didn't get better equipment for this, right? I mean, your equipment that Ms. Gilman has does not amplify the way this does. Is there any suggestion that this is modified in any way, Mr. Lally?
Not that I know of, no.
Have you seen this in this form?
No.
Do you want to take a 5-minute break and see it?
No.
It is just an enlargement of the exhibits. It's just a zoom.
What are you going to do with it?
I'm going to play it until the SUV comes in contact with the Traverse. It's very obvious when you zoom it and you look at the rear tire.
Okay, so you say it hits the Traverse, and then what are you going to do with it?
That's it. Just ask him if that changes his opinion that it came in contact with or was close to the Traverse.
Okay, and you're objecting to that, Mr. Lally?
I think the video speaks for itself. I don't see why you have to.
Mr. Lally shouldn't have asked him the question yesterday. He brought it up.
So I'll let you do it one time.
Okay.
I'm going to try to situate myself where I'm out of the way. If we can have the lights dim, Your Honor.
Sure.
Go ahead and enlarge the rear area of the Traverse. And I'm going to ask you to pay special attention to the back wheel and any movement that you may or may not see. Pause it. Okay, in about the next 3 seconds, Sergeant, I'm asking you to pay special attention to the wheel. Go ahead. think have the lights on. And you can take that down. Sergeant, were you able to see that video? I know it's not the clearest thing in the world. Were you able to see that video okay?
Yes,
What did you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling, it appears that there is movement, but the video speaks for itself.
What would you assess based on the movement of the rear wheel of the Traverse about whether or not the two vehicles came in contact with one another?
Objection.
Sustained.
Okay. May I have just a moment, Your Honor?
Yes.
May I inquire?
Yes.
Thank you. I'm trying to use my time wisely, Your Honor. Yesterday, Sergeant, you were asked about a couple of videos related to the Sallyport garage. Do you have that in mind?
Yes.
As a matter of fact, we watched one of them pretty specifically toward the end of the day yesterday. Did you actually, I want to talk about the one that is the clearer of the two, where you slip. You remember that one?
If you pull it up, I can.
I will in just a second.
Okay.
There was one where Mr. Lally paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was icy that day. So if there's documentation of me slipping, I might have happened.
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos. It's Exhibit 446, but I don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to Canton PD to retrieve any or all of the videos of the Sallyport? You yourself?
I did go to Canton and collect already extracted video.
Okay.
But it was a portion of video surveillance. I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect a portion of the video?
I don't remember.
Okay.
I don't remember. I'm sorry.
Did you review well, let me ask it this way. Did you collect a video that was sought on or about April 23rd, April 24th this year? Meaning just a few weeks ago.
Did I collect it?
Correct.
I did not collect that video of April this year, no.
You're aware that the video that you saw yesterday was in fact collected after the trial started in April 2024?
Objection.
Sustained.
Are you aware of when that video that we saw yesterday was collected?
Objection.
I'll allow that.
I am not aware.
Okay. Was yesterday the first time you'd seen that video?
No.
When had you seen that video previously?
A couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
Sustained.
Did you have a meeting with the DA?
Objection.
Sustained.
Did you ever have any kind of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yes.
So why don't you put your objection on the record? What are you objecting to?
Relevancy.
Go ahead, Mr. Jackson.
I want to find, I think it's highly relevant when he's seen this, if he's prepped for his testimony, how many conversations he's had with the DA, what was the subject of the conversation? That's a standard question we've asked many of the witnesses. It's highly relevant to determine whether or not he had been given any guidance about how he should testify or what he is going to be saying. It goes to basic bias in his preparation.
You're objecting as to whether he be questioned regarding any bias in his preparation?
I mean, I never provided any witness with any guidance as far as how to testify.
I expect that's what he'd say. Are you objecting to it?
Again, I just don't see how any of this is relevant.
You say it goes to bias?
It goes to bias, but it also goes to prior statements of witnesses. If he met with Mr. Lally and they discussed his testimony, I'm entitled to that. I should have gotten a report about it, quite frankly. But short of that,
I will give you a little bit of leeway. Don't forget we are leaving at noon today.
I've skipped over about 2/3 of my.
I am not asking you to cut your cross-examination short.
It's on me. It's on me. Thank you.
You are unmuted.
Mayor?
Yes.
Thank you. Sergeant, did you have any meetings or communications with Mr. Lally in anticipation of your testimony?
Yes.
When was that?
It was about 2 weeks ago, and then last week, I believe.
And what was discussed? Generally.
Generally, we discussed the portions of the case that I would be presenting.
Did you write a report about your communications with Mr. Lally?
No, I did not.
Were you shown any of the videos that you've seen here in anticipation of your testimony?
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Sally Port that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so I don't remember exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You have seen that one before?
Yes.
And that was with Mr. Lally, correct?
That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that Exhibit 446 for a second, and then I'll show it to you. You indicated that the video, all the videos, everything that you saw yesterday was true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place in accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to find out. And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear taillight in any fashion? And you said, never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, or touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion of the vehicle, right? That right rear taillight.
The right rear damaged taillight, correct.
Right. With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
Before we begin playing it, Mr. Bates, if you wouldn't mind, may I inquire, Your Honor, of the witness, just to lay a foundation? Sergeant, do you recognize this as being the video that we saw yesterday?
It does look accurate.
Okay.
Yes.
I just want to make sure we're on the same page. This is 446, just so you have it in mind if I reference that. Bates, if you could play that. If you take a close look at there's a classic police car in that Sally Port, correct?
There's an antique vehicle there, yes, yes.
If you take a close look at the trunk of that vehicle, you see the word police?
Yes, I believe I can read that, yes.
And it's backward, correct?
It is mirrored, correct.
That's a good indication that this is an inverted video, right?
It appears that way, yes.
And if we were to fast forward at 5:42, there you go. Can we just play it at this point? No. Okay, when you pause it. Pause it. You see the Sally Port garage came down?
Yes,
You see a number on the garage?
I do.
Is that correct?
What is correct?
Does the number appear correct? Is that how you make it forward?
No, the number's in the mirror image, yes.
I just want to make the point. Everything in this video is completely backward, correct?
It's not backwards, it's mirrored, reversed. You can look yourself in the mirror in the morning, you still see your own face. It's not backwards.
But my mirror image is not an accurate depiction of who I am. My
Jack.
actual physical appearance is who I am, correct?
Objection.
Sustained.
A mirror image, Sergeant, is not an accurate video of this, is it?
Objection.
It's a mirror image by definition.
Sustained. Ask it differently, Mr. Jackson.
Your Honor, thank you. I don't think I need to. I would like to mark I have a, we can bring the lights up.
Wait.
I have a thumb drive that I'd like to have marked with the court's permission.
Okay. Does Mr. Lally know what's on this thumb drive without you telling us?
I do not.
Okay.
We can approach and I can certainly bring it up.
We're trying to wrap up our morning. It's marked for identification.
If I may, Your Honor, I'd like to play the first 10 seconds of that video.
No. We'll come to sidebar. It's marked for identification, right, Mr. Jackson?
You are.
Why in the world do you think that I would let you play something the Commonwealth has never seen?
Because we got this last night. We did it last night because we just figured out that this was a completely incorrect video that the Commonwealth introduced. And all I did is I inverted it.
Okay, so it doesn't help to say it's incorrect. Tell me what.
It is incorrect.
Tell me what you did and tell me what you have. So you've got
I've got the exact same video to the bit and byte, but it's inverted correctly.
Okay.
It even has the timestamp backward.
How long is it?
Oh, it's exactly the same amount of time as this, which is maybe 5.5 minutes. But I'm not going to play the whole thing.
Okay, so you are not going to play any of it until the Commonwealth sees it. So the Commonwealth needs a copy of it. He's going to have to come back. I imagine you've got redirect, right?
Yes.
Your Honor, if I could get this done, I can tell the court, as an officer of the court, I have not. We have not done anything to this video except the correct way. It's how it should have been in the first place. This is it's a complete deception in terms of where everything is. I want the jurors to see that when you reverse it, that is the car in the Sally port. I don't have to ask a bunch of questions about it. I want them to see the car in the correct way, and one time before 2 days of this is over.
Okay, so if you had given this to the prosecutor this morning, I would have given him time to look at it. Are you objecting?
I cannot until I see what it is.
Okay.
If we could take a 30-second break, I could place the 10 seconds that I want to play, and then we are done. I'm only going to play 10 seconds of this.
Do you have redirect of him anyway?
So I do?
So we have to come back anyway.
I think so.
All right, so we can do it later with him. If this is the end of, I understand we've got a day, and then the weekend. I understand that.
I would just like to get this done. There's a closure that I think I'm entitled to.
No, I understand. You want to have a big score just before the weekend. It's perfectly understandable. But if you had this last night, coming into this morning, it could have been sent over to the Commonwealth, and we could have avoided this. And I understand. So you can either end now without you being done. I can just call it a day if this is the end of your cross.
It is the end of my cross.
Okay, so I will just call it a day, give you an opportunity to do this first thing Monday. If there are any objections, I'll hear from the Commonwealth before we even come in, and you can end it Monday.
Okay, that's fine.
I would do the same, actually, if it were reversed. It wouldn't even be a question, all right? Where do we stand for time? Because the jurors want to know when we are going to finish. Mr. Lally, when do you think you'll finish?
I think the same as I said yesterday. Ideally the 17th. But, most likely at some point on the 18th.
If we get started on the 18th, I think we'll need 5 days to do our entire case.
Okay, so do you want me to tell them that you expect to finish with the evidence? The 19th is a holiday.
It's Juneteenth.
Have you made a decision on the 21st?
Excuse me?
Have you made a decision on the 21st?
I had the court officers tell the jurors that, and I shouldn't be talking about it, moving another case without the lawyers in that case being here. But I'm seeing if the jurors are available, then I might take the next step on that. So let's say you don't start on the 18th. So if you do 20, 21, 22, 20, 21, 24, 25, you'll finish by the 26th?
Maybe even the 25th. I'm giving myself an extra day. I think we can get through with pretty decent alacrity.
Mr. Lally, are you sure you're going to finish by the 18th?
Sure. I'm not sure of anything based on the number of witnesses and not knowing cross-examination length and things like that, but I'm relatively confident that we can do that given, especially if we're going full days 4 out of 5 days next week and then 2 more full days. We should. Ms. McLaughlin was just going through with me. I think we have about 12 witnesses left. I think we can get through 12 witnesses in 6 days.
Okay, I think I can safely tell the jury without being more specific now and tell them I'll be more specific next week. But I think I can tell the jury that they will get this case for deliberations the last week in June.
Yes, including closing arguments, the whole thing.
They will get it for deliberations?
Yes.
All right, I am going to send them home.
Okay.
Thank you, Your Honor.
You are unmuted.
And we're going to have you come back on Monday. Thank you. So we'll just wait. Jurors, I know that you want to know when this case is going to end, and I don't mean that in any negative way. After speaking with the lawyers, I can safely say that you will get this case for your deliberations sometime the last week in June. We'll know better next week. We will not be in session next Tuesday. We will go full days, Monday, Wednesday, Thursday, Friday next week. We will not be in session next Tuesday. I have to give you those cautions again. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Have a great weekend. We'll see you Monday.
You are muted.
I am not changing my testimony, no.
Okay, next question, Mr. Jackson.
You then asked whether the video was true and accurate as in terms of its depiction of what you saw, what you observed in Sallyport that night, correct?
I indicated the video is true and accurate to the location.
And you were then asked whether or not, in looking at that video, watching it, either you or Trooper Proctor approached, manipulated, touched that right rear taillight at any time, and your answer was never, correct?
That's correct.
And while you testified, this is the video that was displayed for the jurors, correct? But it was this orientation, the front of the truck facing right, the rear of the truck facing left, correct?
That's correct.
And for all appearances, it would appear that the right rear taillight of the SUV is the one facing the jurors, if you will, facing the viewer, right? From appearances. You didn't know anything different.
Can you rephrase that question, please?
Sure. Just from the appearance of the video, as it is now, the appearance of the video looks like the right rear taillight is the taillight that's facing the jurors, facing the viewer, toward the rear of the truck, correct?
As it is frozen, correct.
And on Wednesday, I want to move through this relatively briefly, Sergeant. On Wednesday, you did not mention that this video was inverted, did you?
It was not brought out, no.
Not brought up by, I mean, that's a passive way of saying it. I'm asking you directly. Did you mention that this was an inverted video?
Not on Wednesday, no.
On Thursday, Mr. Lally finished his questioning on Wednesday, then came back on Thursday. You continued on direct examination under questioning by Mr. Lally again to start the day, correct?
That is correct.
And during that testimony on Thursday morning, you also, under direct examination, did not mention that this video was inverted, did you?
Did not know.
And then it was my turn to ask you questions. You recall that?
I do.
And then I began asking you questions about the accuracy of this video. And at that time, for the first time, you said it appears that it is a mirror image. It's an inverted video, correct?
I advised you that it is a mirrored image at that point, correct?
Would you agree with me now, as you sit here, that this video, as we're looking at it, is not a true and accurate depiction of what you viewed in that Sally port that night?
I would not agree with you, no.
You believe that what the jurors are seeing right here is a true and accurate, surveillance footage of the Sally port that night?
Yes, it's just mirrored.
Which means what's left is right and what's right is left, correct?
Correct. If the jurors were actually standing where the camera is recording, which it's recording all accurate depiction of activity and events taking place, the back of the vehicle would be on the right and the front of the vehicle would be on the left, but all activity is accurately depicted in the video.
So, in point of fact, everything in this video, every bit of it, is reversed, correct?
It's just a mirror image.
So it's not accurate, is it?
It's an accurate depiction of what is taking place.
Sergeant Bukhenik, if I were to ask you, let me give you a hypothetical. Let's say you were investigating a circumstance in which a suspect was being identified by 5 witnesses based on a tattoo on that person's left arm. And then you go show that witness, or those series of witnesses, an inverted version of a photograph of that person with the tattoo appearing on his right arm. And those witnesses all say, no, that's not the guy. I remember the guy. The guy had the tat on the left arm. Would you think that that's an accurate depiction of the person with the tattoo?
Objection.
Sustained.
Do you agree with me that an inverted video is not accurate? It's inverted by definition, right?
It's an accurate depiction of the events taking place.
You've reviewed this video in its entirety, testified, correct?
Yes.
About how long would you say this video is in its runtime, from start to finish?
I did not take note of the length of the video.
All right. I'm going to ask you, Mr. Bates, if you could, with the court's permission, can you just pull the cursor back to the beginning of the time of day for this video? And pause it there. Can you see, and this is not an eye exam, can you see the timestamp on the lower left-hand side?
No, I cannot.
Your Honor, with the court's permission, I could do this.
I'd like to see it sidebar.
I did tell you before no demonstrations without me knowing about it. With the court's permission, I'm going to do this. Say yes, because you didn't tell me what you were doing until after he did it. Be careful of those things, Mr. Jackson.
Well, when I think of it, I will obviously let the court know. I wouldn't want to.
No, something with the time. What do you want to do?
I thought he might be able to see it.
Do you have a still?
I don't have a still, but he could step off the witness stand and take a look at 2 times, the beginning time of day and the end time.
What are the times?
5:30 and 5:48.
Are you in agreement that the times are 5:30 and 5:48?
As a beginning time, I'll take counsel's word for it.
Can we just stipulate?
Well, that's what I'm asking. Do you agree?
I think it's roughly what it is, and I can just say the runtime of the video was 5 minutes and 51 seconds.
Those are those things. That's what I need out of this witness.
All right, so we don't need the times. We can figure out the times. But the runtime, you agree with this, 5:51?
Uh-huh.
They'll have it. You'll have it, and you can argue it.
I realize that.
You don't need to get it from the witness.
I do need to get it from the witness. At the time, I need him to acknowledge that this is not a complete video, that there are times missing.
It's motion activated. Is that why the times...
I don't know.
Was that testimony on this, or was that was testimony on this, right?
Yes.
I know I heard testimony on motion activated.
Your Honor, this is my cross-examination.
Right. I'm not going to let him get up and look at it. You've got to stipulate
I'm happy to do that.
that it is 5 minutes and 51 seconds.
5 minutes.
What did you say it was?
I believe it's 5 minutes and 51 seconds of runtime.
5:51, 5:52. I'll stipulate to that. And also, if I could just get a stipulation for the beginning runtime. I'm sorry? The beginning time?
Oh, you're saying the time is longer than the 5:51?
It's 17 minutes. It should be 17 minutes long.
It is. It's motion activated.
So do you agree that it's 17 minutes long?
Roughly, yeah.
It should be. It's not, but it should be.
Are you satisfied with that time?
5:30, 32.
5:30, and then whatever. And then it goes to 5:48 and whatever. I've got the times in my notes, the exact times.
You don't have to get it from the witness if you get it from Mr. Lally, right?
Right. If we could have one or two questions of the witness based on that.
That sounds about right. I don't know the end time offhand.
Why don't you have him just put it down? Put it at the end time. You can look at the end time, and then we'll move on.
That's exactly what I was.
You're not going to get it from the witness, and I'm not going to make him come up and do a demonstration.
It's not even a demonstration.
I'm not going to have him.
If we had monitors on the witness stand, we wouldn't have to.
And if you had a still shot, you could show him. So, okay. So you've agreed it's 5:51, right?
Yes.
You both tell me what your stipulation is.
That the beginning time of day is 5:51, and I'll fill in the second.
No. The beginning time is 5:30.
I'm sorry, 5:30 and a number of seconds. It's in my notes.
Okay.
The end time of day is 5:48 and the number of seconds, and I'll fill in the blank.
Okay.
But the total runtime is 5 minutes and 51 seconds.
Do you agree with all that, Mr. Lally?
The end time is 5:30:23 to be precise.
And time ends. The end time is what?
The end time is 5:48 and the number of seconds is in my notes.
Okay.
That's 5 minutes and 51 seconds total runtime.
So do you want me to tell the jury this?
No, I'll do it.
Or do you want to tell your witness?
I'm just going to ask for a stipulation first. Mr. Lally, the Commonwealth stipulates to these two times.
So that's typically not how it's done. I tell the jury that we have the following stipulation, and then you can say what the stipulation is. You cannot question the prosecutor during the course of this trial.
I'm not questioning him.
No, I'm just telling you.
I'm asking for the stipulation.
Please, let me talk.
I have let you talk. You are not letting me make a record.
Oh, you've made a record. The prosecutor is agreeing to this. You can't openly say in court in front of the jury, Mr. Lally, will you stipulate to this? That's all I was saying to you.
Understood, understood.
Your Honor, I do have the end time. It's 5:48:15 seconds.
Okay, I am going to tell them that the parties stipulate that the video begins at 5:30:23 seconds.
Yes, Your Honor.
5:30 p.m. and 23 seconds, and it ends at 5:48:15. All right, and that the total runtime is 5 minutes and 51 seconds.
Correct. Thank you. That's all I need.
You are unmuted.
Jurors, sometimes lawyers have what we call stipulations rather than prolonging either testimony or calling an additional witness. Lawyers agree as to certain facts. So what the lawyers have agreed to here is that this video begins at 5:30 and 23 seconds, 5:30 p.m. and 23 seconds, and it ends at 5:48 and 15 seconds. And the total run time of the video is 5 minutes and 51 seconds. All right, your questions, Mr. Jackson?
Thank you for that, Your Honor. Sergeant Bukhenik, given the fact that the beginning time, the time of day, is 5:30 and 23 seconds in the evening, and the end time of this video stops at 5:48 and 15 seconds, would you agree with me, without doing the math down to the seconds, that's about 17 minutes and 50 seconds or so?
In real time, yes.
In real time. The actual time of this video, the run time of this video, however, is only 5 minutes and 51 seconds, less than 6 minutes. You'd agree with that?
That is what's captured.
So that means that about 2/3 of the video is missing, correct?
It's not missing, just not recorded.
It's not there.
It was never there.
I'm not saying it was ever there. I'm saying I don't know if it was ever there or not. Neither do you. I'm saying it's not there, correct?
It was never recorded.
Well, you don't know what has been or and wasn't recorded, do you?
Objection.
I'll let him answer that.
I can only speak to what was turned over and what we received, and based on the evidence that was produced, the video that was produced is what we got.
I understand. So based on that answer, you acknowledge you don't know what may or may not have been recorded without your knowledge.
No.
Right. Positive. Did you see that the person walking away from the vehicle that you earlier on Wednesday identified as Trooper Proctor appeared to have a notebook, black portfolio in his hand?
Yes, I did.
And can you see from there, I'm going to ask you this, basically knowing the answer, can you see from there the time of day on the lower left side as that person leaves the screen?
No, I cannot.
Would you disagree if I indicated to you that was 5:38 and 7 seconds in the evening?
I would have to see it for myself. I cannot agree with you based on your statement.
Your Honor, may we approach briefly?
Sure.
So he said he'd want to see it. I'm going to let him see it. That's what you're asking, right?
Out of respect for the court's preference,
No, and I appreciate that.
I think a stipulation to that time is fine, just 5:30.
Or you can ask, he said he'd have to see it. So do you want him to go see it?
Sure.
You are unmuted.
All right. So, Sergeant, we're going to ask you to go take a look at that, okay?
Thank you, Your Honor.
And please don't speak until you're back in the witness stand. Thank you. All right, Mr. Jackson?
Thank you. Sergeant, did you have an opportunity to look at the time of day at the point that the video is paused right now?
Yes, I did.
What is that time of day?
5:38:07.
5:38 and 7 seconds, correct?
That's correct.
And remind me about how far of a drive in time is this location at Canton PD from 34 Fairview?
With no traffic, no adverse weather and road conditions, several minutes, four minutes maybe, 5 minutes, depending which route you take.
Your Honor, I have a flash drive that I'd like to have marked.
Is this a different flash drive than we had on Friday?
It is, and I can explain it sidebar if the court wishes.
All right. Are you just marking it, or you intend to show it?
I intend to show it with the court's permission.
All right. So we'll mark it for identification, and then I do need to see you. Yes. Thank you.
Maybe approach.
Yes.
Have you seen it?
No, he has seen it. This is the same video. We sent it to him yesterday, the same video that we had on Friday. It is this video inverted. When we received the original video from the share file from the Commonwealth, it was in an executable format, an EXE format, which is weird. It should have been in just a video format. So this video has the proper time of day on it, 5:38 and whatever it is, but it's completely inverted. You can see it. So it's exactly this video, just inverted. There's no difference whatsoever.
You sent it to the Commonwealth yesterday?
We did. Actually, Saturday.
You haven't seen it?
I've seen as far as the video that was produced on Thursday. I took a quick look at this in the sense that it appeared to be the same video that was sent. That's what I thought was being sent. It was just a formal copy of what
Oh, because you hadn't received it because I took it?
Ms. Gilman had burned a copy. So that is why I didn't really bother to look at something that appeared to be the same thing.
And it is the same thing. It's exactly this video, just literally the mirror image.
How is it different than what we had on Friday?
The one on Friday, I don't know. It may be the same, but there is an anomaly that occurred in one of the versions of the video that we saw that we received from.
No, but I mean you said on Friday.
That's what I'm explaining. I don't know because I don't have it.
Hold on 1 second. Jurors, we are going to give you a 10-minute break.
Good, all right.
I am prepared to allow in what was marked YY on Friday because the Commonwealth has seen it.
Your Honor, that was marked today. It was XX.
XX, Thursday. Are you objecting to XX being?
No.
So show Mr. Lally the other one, and I'll come out and hear you.
The only difference, I'll tell the court, the only difference is the blue timestamp on the bottom says UTC -5 versus UTC -8.
Well, so show him.
Okay.
Are there any other surprises, any other differences that we can deal with rather than we've been at Sidebar a few times?
The only other thing that I want to do is play the dark, grainy video, which is in 446. I think that's already been played.
It's already in evidence.
That's it.
I want to hear you on the Trooper Proctor motion that the Commonwealth wanted renewed for today as well. What do you intend to do regarding the internal affairs?
Nothing.
Not mention it to at all?
No, I'm not seeking the introduction of that at all.
Okay.
My cross-examination is going to be based on bias.
Federal grand jury minutes?
The federal grand jury minutes. A lot of the information that came out in the federal grand jury minutes will be reflected in my questioning of Trooper Proctor, completely excluding anything having to do with the...
Does that answer your question?
It does. The only other questions I have were twofold. Number one, as it pertains to bias, I certainly understand certain statements contained within the text to friends and family, as well as other troopers fall into that category. I don't think that there is any text messages with any Canton police officers that have anything to do with bias. So I'd raise that. Secondly, and I'm just going on sort of my understanding as far as protective orders are concerned, that I don't believe any of the text messages or any of the items contained can be displayed on the screen. And I'm not saying counsel intended to do that. I just want to clarify that before.
Are you stuck with that protective order as well?
No, I don't think so. No, we've redacted everything having to do with TUI, coming from the AUSA. All of it's been redacted. It's just the text messages are there, downloaded, their extraction from an iCloud account. So we've been told we can, inside the four corners of the courtroom, we can use anything we want to.
Okay.
And I'm not disputing that as far as using what you want to. I just don't know if that includes publishing it on a screen.
We were not told that the use and publication to the jury is separated. The anticipation is you use it in the courtroom, how you use it in the courtroom, displayed or otherwise. There were no restrictions.
Do you intend to introduce, have copies of it?
I do.
Okay.
I'll mark each hard copy and in the same way that Mr. Lally has done.
Show Mr. Lally what it is you intend to introduce.
He's got everything. It's the text messages, group chats with friends, group chats with colleagues, the MSP colleagues, which we are well aware of.
How about with Detective Albert? That's what you raised, right?
Detective Albert and Sergeant Good.
Sergeant Good? I don't think I have anything with Sergeant Good that I'm interested in. Sergeant Albert, I'm sorry. Detective Albert, yes. There will be a couple of text messages back and forth. We have redacted a portion about...
Regarding. Because there is an argument objecting to Detective Albert. So show Mr. Lally what you intend to introduce.
Of course. Sure.
So this will be very quick. Just show Mr. Lally.
Yes.
All right. I'm going to take a 2-minute recess.
All rise for the court, please. Court back in session, you may be seated.
Does counsel need to see me, or are we all set?
I think we're all set.
Okay. Right ahead, Mr. Jackson.
Thank you, Your Honor. As a matter of housekeeping, I would ask for the admission of the last item that was marked for identification.
XX. Was it YY? Oh, there was back again. Okay. All right, so that will now be what, Madam Court Reporter? Thank you.
And with the court's permission, I'd ask to display that video. Yours?
Okay.
Bates, if you could move that to a runtime of 1 minute and 17 seconds or thereabouts. And go ahead and pause that. Sergeant, do you recognize what's depicted in what's just been marked as Exhibit 542?
I do.
How do you recognize that?
It's an inversion of the video provided from Canton PD Sallyport.
It's actually, and that inversion corrects the perspective. Would you agree with that?
I would.
Okay, so now we're looking at what we've always been looking at, but it's clear that we're looking at the driver's side of the vehicle, correct?
That's correct.
And everything in it's properly oriented, is that right?
It's an accurate depiction of what is taking place.
Meaning right is right and left is left in this video.
The vehicle came from the right into the left. The driver's side is visible and is closest to the camera.
If we could go ahead and, thank you, Sergeant. If we could go ahead and play this for just a few seconds, please.
Now, again, you had a conversation or an interview with the defendant on the afternoon of January 29th when you were indicted, correct?
That's correct.
And during the course of that interview, she made statements about her broken taillight and when that occurred, correct?
Objection.
Do you want the instruction, or do you want to come see me at Sidebar?
Sidebar, please.
Did you get the whole sentence out, the whole question out?
Yes.
Okay.
It's outside the scope. Her statements I never addressed.
That's not outside the scope because he's raised as far as issues where Trooper Proctor was around the taillight. And the defendant said to them earlier, hours before they were back at the Canton police station, that she broke it the night before.
Which you got out on direct examination, which I did not address on cross.
All right. You are implying that Proctor broke the taillight?
I'm implying that Proctor was standing near the taillight based on video surveillance. I'm not implying it. He was standing near the taillight based on video surveillance.
Okay. If you intend to argue it, I'll let the prosecutor get this question in.
He's allowed to get in questions that he asked on direct examination.
This is one of the problems of taking so many days off. You didn't touch upon this at all?
No, zero.
All right. I'm not going to allow it. You can argue it.
Understood.
You are unmuted.
Between the version of the video that you and the jury witnessed on Wednesday and the version that you just witnessed the entirety of right now, again, what, if any, difference as far as the depiction or people or places between those two versions of the video?
Outside of it being a mirror image of itself, it accurately depicts any activity or action in the Sallyport.
And at any point in time that you were in the Sallyport area of the Canton Police Department garage, did you or Trooper Proctor ever go near, touch, manipulate the rear passenger side taillight area or the rear passenger side quarter panel of the defendant's vehicle?
We absolutely did not.
Now, if I could turn you back to some questions you were asked on cross-examination about something that was reported to the Chief Medical Examiner's office. Do you recall that?
I do recall that.
And some questions about statements that you had made to the OCME at approximately 10:41 a.m. on January 29th. Do you recall that?
I do recall that.
And you were asked some questions about reporting it as a possible domestic assault, correct?
That is correct.
And can you explain to the jury what led to that statement as far as what you knew at that time and why you would make those statements to the medical examiner?
The Massachusetts General Law directs us, just as it gives the district attorney's power to and authority over all death investigations. That's the following section 4 of that chapter. Excuse me, following section from section 4, section 5 of that chapter directs all state medical and police entities to work in coordination with the medical examiner's office. By law, we're supposed to work together on the medical legal investigations that the medical examiner's office conducts. We conduct the criminal portion of the investigation, they conduct the medical portion of the investigation. Thus, I contacted the medical examiner's office and advised them that what we had learned at the time. Up to that point, we had learned that the defendant stated that she hit him. We had collected, meaning the Canton Police Department had collected a broken glass. So based on the physical evidence and the statements made by the defendant to the first responders at the scene at that point in time, I had communicated those facts to the medical examiner's office. That way they would document it, but also be prepared to investigate the case with the most up-to-date information available.
Now, at that time that you made that statement to the representative from the chief medical examiner's office, had you been to Good Samaritan Hospital and seen Mr. O'Keefe at that point?
I have not.
And had you obviously seen any of the injuries that Mr. O'Keefe had sustained prior to making that statement to the medical examiner?
I had not.
Now, as far as the information that you received, you mentioned first responders indicating that the defendant had stated, "I hit him." Who was the first responder that provided that information?
Be Canton Police Sergeant Good.
In addition to that, did you or Trooper Proctor speak with any of the Canton Fire personnel?
Yes, we did.
And who did he speak with?
I believe it was firefighter Fleming.
So firefighter Flamati, is that correct?
That's correct.
Now, after going to Good Samaritan Hospital and viewing Mr. O'Keefe's injuries, as far as what you had earlier reported to the medical examiner, what, if anything, changed based on those observations as far as your opinion as to what had transpired?
Based on what I learned from observing the injuries, I could tell that the glass.
Objection.
Yeah, I'm going to allow it. You can move to strike it, but I'm going to allow it.
I could tell that the glass was most likely not the object, the weapon, which was used to cause the injury to the back of Mr. O'Keefe's head.
Thank you, sir. I have no further questions.
Any recross?
Very briefly.
Okay.
In your report to the OCME, you said there's a glass to the face, not to the back of the head, correct?
I'm not sure how they wrote it down, but I would need to be refreshed on my memory.
Okay, fair enough. Any approach?
Yes.
Thank you, Sergeant. Does that refresh your recollection?
Yes, it does.
What did you say to the or what did you report to the OCME?
That there was a possibility that the decedent was struck to the face with a glass.
You also, with regard to the phrase, "I hit him," or the Sergeant Good and or Flamati telling you that she said, Miss Reed said she hit him. When did Sergeant Good tell you that?
It would have been during our conversations at the police department.
And when did EMT Flamati tell you that?
He never told me that.
So the only thing you were going on with regard to the phrase or the statement that you claim my client indicated, where my client indicated she hit him, is coming from Sergeant Good.
That information at that time was provided by the first responders from the scene.
And Sergeant Good then relayed that to you, correct?
At some point, yes.
Is there a single report memorializing that Sergeant Good reported to you that morning before 10:41 a.m., before 10:41 a.m., that my client made the statement that she hit him?
I don't believe so.
I want to shift gears real quick to the video. A couple of quick questions about that. When did you, and I'm talking about the higher quality video, like the one that was inverted. When did you receive that video? What date?
I'm not sure. It was at some point in either late April or early May.
After we had started this trial.
Objection.
Do you know?
I do not, Your Honor.
Okay.
It was after mid-April, correct?
I believe so. I'm strictly speculating.
Who asked you to retrieve that video?
I did not retrieve that video.
I'm sorry, that was a presumptuous question. At what point were you asked to secure the video, or were you ever asked to secure the video?
That video was never secured by me. I was not asked to secure it. I just was asked to review it.
Okay, so who did secure the video to your knowledge?
I do not know.
You are aware that it was, well, let me ask you a couple of different questions then, based on that. You've already testified that you knew that the Canton Police Department was recused from any investigation concerning this case, correct?
At one point, we learned that the Canton Police Department, the decision was made way above my level, and I was advised by Detective Lieutenant Tully that Canton Police had recused themselves from the investigation as far as interviews go.
And you knew that that recusal was because of a connection between the Canton Police Department and the Albert family, correct?
Objection.
Sustained.
Did you know, or were you informed, that the recusal was based on the connection between the Canton Police Department and the Albert family?
Objection.
So it's sustained for the same reason I sustain the Commonwealth's objection at sidebar, Mr. Jackson.
Last question. Who provided the video?
I do not know.
Canton Police Department, wasn't it?
You asked who? That's an entity.
Okay. What entity provided the video?
It came from the Canton Police Department.
Thank you. That's all I have.
All right, Sergeant, you are all set, sir.
Thank you, Your Honor.
Your next witness, Mr. Lally?
Yes, Your Honor. Commonwealth call Officer Nicholas Barrows to the stand.
Okay.
Goodbye.